Butera.
Okay.
Mr. Fallon? You may proceed.
Thank you. Richard J. Fallon for the defendant appellant, excuse me, Michael and Janet Butera. Before I address the substantive issues, I want to very briefly mention what I think is a serious subject matter jurisdiction issue. That is, as interpreted by the Harrison case, a 1969 case of this court, Chapter 240, Section 14A, authorizes challenges to zoning ordinances concerning someone else's land if there's a direct and adverse effect on your land. And Harrison says that statute should be interpreted broadly. But, and here's the but, there's no verified complaint here or affidavits here. And I simply suggest that you consider whether without that, whether there is subject matter jurisdiction.
Oh, they're next door neighbors, aren't
They are joining the next door neighbors, Your Honor. But again, as I'm saying, I believe it is a subject matter jurisdiction issue, and I don't believe on the record there's a showing. But I'll move on to the substantive issue, Your Honor. And I point out that from the moment it was suggested that there was untrammeled discretion to the permit-granting authority of the Western bylaw, the Butera's position has been clear and consistent. And that is that Section 1B of the bylaw provides sufficient standards. And the bylaw sections, and I believe it's black-letter law, have to be treated as a whole, Your Honor. And Section 1B is pretty specific. It talks about
any premises which is injurious, obnoxious, offensive, so forth?
to the community or neighborhood. It talks about smoke, gases, noise, etc.
Well, aside from 1B, why can't we read the word may just as a word of authorization? There are cases that say you can read the word may that way, and that would provide sufficient standards then.
That's the town's argument, Your Honor.
If may is a
That's
word
the
of
town's
authorization.
argument of its own bylaw. I have to admit, our argument has been different, and we followed the land court, but I'm sure as heck not going to argue with you if you want to go that way.
No, but either
Yes.
interpretation is possible without
Surely,
getting
if you
into
use it that way, I
1B.
think it puts everything to rest, because that's saying if
Well, either way, we've upheld bylaws that have had a lot less in them as so-called standards than this one.
I believe you have, Your Honor. And indeed, if one looks at the commentators, and the two I found were Levy, 1996 book, and Grabowski, 2000. You know, Levy says, at page 187, the courts have been lenient upholding special permit provisions with only general standards. And of course, Grabowski, that's at page 271 of the second edition. It says the courts have been extremely generous in reviewing such regulation.
Is this a special permit?
Yes.
Well,
Does it matter?
It isn't.
Does it matter?
I don't think it matters, Your Honor. Actually, they used to do this by special permit, and then they changed it just permit. I mean, it's one of those things, if you wanted to decide what has to be by special permit, I don't think you have to at all, Your Honor. And so I haven't really got into that. And I don't think it makes any difference. Though I would point out that the special permit standard is almost word for word similar, or it's very, very similar. That's at Appendix 144, I believe. But that's, in other words, the special permit standard of the town uses very similar language. Proposed use will not be injurious, obnoxious to the community or neighborhood noise. It's almost exactly the same language. And, you know, as I pointed out in my application for further appellate review, I really think if you went the appeals court way, you'd invalidate every bylaw in the Commonwealth of Massachusetts and every special permit, because I think this is one of the best ones. This is actually one of the more specific ones. But I'll tell you, it's interesting, Your Honor. The thing about the appeals court decision didn't mention any cases that went the way of saying not sufficient standards. And there's a Smith case that's really kind of amusing because it's 1946, and it's obviously everybody coming back from the war and new families, and they said any building you can have for up to 6 apartments, you can change any building as long as you don't just change the exterior. You can make any building in the town multifamily. And the court said appropriately on that one, that's throwing away the whole zoning.
But in addition to the, not injurious, obnoxious, and all that kind of stuff,
Yeah.
the bylaw itself says it has to be, the use has to be in connection with commercial or business activities.
Oh, yes, and that, of course.
Providing services essential to the uses of the premises in residence districts. That's a standard in and of itself.
Oh, exactly, Your Honor. And that actually even goes more to the second independent ground where they said storage wasn't defined and it wasn't specific. Because the bylaw, Section 5B5, you're exactly right, is very specific. It says it has to be storage for particular things, vehicles, material equipment, in connection with commercial or business, principally carried on in the town, and providing service essential to premises in residential district. And it's clear what it's intended for. It's intended so in the town of Weston we can have some people who will do the plumbing and who will do the landscaping.
And that's what this Mr. Butera did.
Well, exactly. That's the whole point. And, one might surmise, indeed, that's why the town was very happy to grant the
Well, what do we make of it? What do we make of the fact, and I know you say this is completely irrelevant, of the fact that the building, I assume, where most of this stuff is stored, was built subject to a variance in 1991, which certified that it was to be used for personal use only.
It didn't. I mean, there's a couple of points, but the first thing, it did not. In fact, what the condition, if one looks at that, and I believe it's appendix page 17, A17, if one looks at that, it does say we're planning to only use it for residential, but at the bottom it says, in granting the variance, providing that the height does not exceed 20 feet. The condition was that the height does not exceed 20 feet. And if there's any question about that, it's black letter law that the interpretation should be by the board, that you look to the board for interpretation of the, and of course, clearly by granting the 1995 permit here. This is the second permit, the 2003. In granting the 1995 permit, the board clearly indicated that their interpretation was it was not a condition.
So this 1991 variance really is no longer of any consequence. It's just an interesting historical fact.
No, well, it's of consequence as to the issue of the variance, but as to the permit, this is a special permit. It's a whole different animal. We're talking apples and oranges. And also, as I pointed out, I think it's kind of too late for him to do that because in 1995 he didn't oppose. He didn't oppose the special permit in 1995 at all. It's a little too late to come back when you're amending. In other words, this isn't amending the variance. He's trying to argue it's amending the variance. It's amending the special permit that Attorney Fordham didn't oppose in 1995. But, I guess part of my job here, and I don't want to take up too much time, but the one thing, part of my job here, I think, is to give principles. And one case in which isn't cited in my brief, but in which they did find no sufficient standards. And I think it's interesting language. It's Commonwealth versus Protami. It's a 1968 case, 354 Mass 210. And the local bylaw there said no person can have more than one registered car in their residential premises unless authorized by the Board of Selectmen. And that's pretty much what it said. And this court very reasonably said at that time, well, geez, you're leaving it to the unrestrained discretion of the selectmen. And it said the landowners, but here's the language that I thought was very important and for a principle. The landowner, and I quote, the landowner is deprived of any basis on which he might appeal for some determination of the propriety of the conduct of the selectmen in withholding the authority for an extra one or not. And I kind of think that really is the principle here. No one should, Board of Selectmen or lower court, in fact, this court should have the final say. And so no court or board should have a completely arbitrary, completely untrammeled discretion, as McGibbon said, to make a decision and have no review. And I think that's the key point. You look at what the standard is, and you say, is that completely unreviewable? And my suggestion, Your Honor, is when you look at 1B, when you look at how specific it is, and of course it has to be general, when you look at how specific it is, you say, sure, there's a lot of things that they can review. And so that's why it isn't unconstitutional. It's not in violation of due process. And if you don't have any further questions, I'll sit down.
Thank you, Mr. Fallon. Mr. Fordham?
May it please the Court, thank you. I'm starting off argument to answer Justice Graney's question with respect to Section 5B5. 5B5 sets forth an eligibility standard and nothing more. It does not, if you rise above, if you're in one of those two businesses, a permit may be granted, but it does not set forth a standard. Indeed, the fact that it does not set forth a standard is best shown by the position taken by the public defendants. That is, the ZBA has interpreted this bylaw as mandating the issuance of permits if the eligibility requirement is met. That's not the position taken by Mr. Butera and Mrs. Butera.
Mr. Fordham, what if you read 5B5 and IB together, the two bylaw provisions?
I don't see why you should. And what you do if you do that.
I'm saying read them as a whole, as opposed to just focus in on 5B5.
I think the answer to that is simply that it eliminates the middle category and it automatically makes prohibited, something that isn't prohibited becomes permitted. And therefore, you essentially wipe out what the lower court, that is the land court, noted, if I can find the page reference, the land court noted that there's permitted, which it's conceded this isn't, there's prohibited, and then there's this middle category, and that's what's before this court, the middle category. And I simply submit the rhetoric of Section 5B5 contains no standard. We're not arguing about whether it's an adequate standard even. There is no standard in Section 5B5, and that's the point of my referring to the position of the town that 5B5 is mandatory.
But would you say there are no standards in the IB bylaw? It prohibits. Excuse me. Sure. It prohibits any use of any building, structure, or premises which is injurious, obnoxious, offensive, dangerous, or a nuisance to the community or to the neighborhood. Aren't those standards?
That's prohibited. It isn't permitted because it's not prohibited. You go from permitted to proscribed under that section to the whole middle category of what is allowed by one kind of permit or another. And in that situation, the case law requires a standard. And I'm simply saying we're not arguing about the adequacy of the standard because there is no standard at all.
But Mr. Fordham, why is it not a standard if you say anybody who has a business and it's essential to the business and it's exclusively or mostly for town residents and it is neither obnoxious or all those things in 1B5 is entitled to a permit? What, is there something wrong with that?
That's not what the town has done. It could have done it, I suppose, subject to argument.
But hasn't it really done that? By if you put those two things together, 5B5 and 1B?
Then you're meeting the argument that may means must, and that's the way the board has interpreted it. But the land court has specifically considered that argument and has rejected it in a late page of its first decision, which is an appendix, an addendum to the defendant's brief. It's at the first decision of the land court at page 10 specifically addresses that question, and it seems to me dispositive of it. Looking at it from the standpoint of purpose, why would, I'll ask a question, but it's rhetoric, I don't expect an answer. The land court, why should the town permit this to be allowed anywhere in the town simply because it isn't prohibited? That does not make good sense from the standpoint of the purpose of land use law.
So what you're suggesting is that even though, maybe you're not suggesting this directly, even though Section 1B might have some standards, the town doesn't view them as being applicable to this form of permit because this is permitted as long as the criteria are met.
The town would have had to first consider whether it was prohibited. And if somehow this case ends up back below, I will make a much different presentation at the Board of Appeals level. But it has to do that, and then it has to act under 5B5. Both are required if it's an eligible business under 5B5.
So the board never looked at 1B and in fact contends it doesn't have to look at 1B. Those aren't standards that apply.
There has to be compliance with 1B or it's prohibited.
Then
Period.
Then why isn't that a standard that relates to this
It's a
case?
prohibition. It's not a standard. There is no standard in 5B5. If you simply read the words of 5B5 and the interpretation placed on 5B5 by the Zoning Board of Appeals, by the ZBA in its decision that the permit was mandatory. Taking may to mean what may means, it has unlimited discretion if it's not prohibited in accordance with that argument, and that violates the well-established principle that there's got to be a standard. That's the basic flaw in the argument that my brother makes, and I think he did an eloquent job of persuading this court to take the case.
You're saying it's not that it has unlimited discretion, it has no discretion at all. I mean,
It has no discretion at all because there's no standard. They argue that they are obliged to issue a permit under 5B5 if
there's no prohibition.
If there's an eligible business.
Right, but I mean, first they have to make sure that it doesn't fit within any of the prohibited categories in 1B.
That's right. But they have to do both. And it's the lack of a standard that is, in my mind, crucial and is the fatal flaw in their argument that there is no standard in 5B5. I'd like to take a minute and explain to the court why I've raised all these other issues persistently from court to court to court. The reason is, one, I don't know what this court will do. Two, I don't know what the defendant will do. And three, I don't know what the town will do. And that suggests to me that in the interests of efficiency and economy in the judicial process, the court ought to look at the other issues, or we're going to end up back here possibly or probably 5 years from now. And that goes in part to the point raised by Justice Cordy. The decision of, first of all, with respect to the variance, I just don't agree with that point at all. The variance is alive and well. If it's for personal use, there's no reason to oppose it. I couldn't reasonably, as a decent neighbor, object to a proposed barn for personal use. The application explicitly says for personal use, and the first sentence of the last paragraph says, on consideration of the petitioner's expressed needs for the storage of vehicles for personal use. That's the relevance. Then there's the relevance of the 16B letter that I filed with the court and the case cited there.
I have to say I didn't quite understand.
Okay.
You're talking about your Fifth Circuit case?
Yeah, the relevance of the case, Your Honor, is that the court renders, meaning renders judgment.
Well, I don't understand.
Well, it's not a word in my vocabulary, instead of remands, and it does so in the interest of the efficiency of the judicial and legal process. That's a basis upon which I urge the court to look at these other issues, but I haven't been able to persuade anyone else of that, and I have no grand and glorious illusions, meaning I may be back here 5 years from now. I do want to point out that the matter arises on a motion for summary judgment, and the reason it arises on a motion for summary judgment is that there is a permit issued in furtherance of the decision, and the permit includes two documents which the zoning board required that the defendants submit to them. So the defendants have described their business extensively. They have submitted a plan, and there's just no genuine issue of material fact. There are references beyond that to phone books, but that's surely a proper subject of judicial notice. I think I'm done, unless somebody has some questions, but I just quickly want to run over this list. Oh, yes. As to the first point he makes.
Let me just go back to the barn. Did the variance that was granted, was that a variance from a height requirement, or was that a variance for, an accessory use, something like that? Was it to build the barn in the first place?
The application is to build the barn for personal use, and
but could they have built a barn on the property if it were less than 20 feet high, if it were 10 feet high, as a matter of right, without a variance?
I think the answer is if they met all the other requirements, and I think that's probably the only relevant requirement. They could have, but they couldn't have instantly put it to business use.
No, they couldn't have, and that's why they applied for a permit in 1995, I assume.
Well, the permit in 1995 is for so limited use. Again, there's no reason to oppose it. He wants to put one truck in the barn, and as a good neighbor, who cares? And so in both cases, I look at the application, and I see no reason whatsoever why I should oppose. It's when he starts adding and adding and adding to the point where he has numerous trucks, a lot of employee parking, and so on and so forth, that it becomes a problem. If he had limited himself to what he asked for both times from the zoning board, we wouldn't be here. I would have no reason whatsoever to object to what he was doing, but he needs a variance to change the use. The bylaw explicitly prohibits use variances, and as the court knows much better than I do, use variances have always been a problem, which is why the town has absolutely prohibited them. So assuming he could build the barn and use it for personal use, he can't use it for business use because the bylaw explicitly prohibits use variances. He didn't ask for one, and I don't think the permit from 2005 converts the variance into something else. If you want to amend the variance, you got to amend the variance. And if he tries to amend the variance for business use, the argument to the Board of Appeals is it's prohibited by the zoning bylaw itself, literally and explicitly. The last point I wanted to raise, unless there are more questions, is the issue first raised by opposing counsel is not, I think, a jurisdictional issue, and yes, it's next door. It wasn't raised below in the land court. It wasn't raised in the appeals court, and it doesn't belong here. Beyond that, unless the court has some questions, I'm through.
Thank you, Mr. Fordham.